International courts and tribunals produce judicial determinations or decisions on the basis of international law. These actors are the suppliers of the fourth source of international law, which are judicial decisions. International courts and tribunals resolve disputes between states, like territorial disputes and matters of jurisdiction. They also settle economic claims, provide legal remedies to human rights violations, and pass judgment on international crimes. Two general terms to note about courts and tribunals. One is whether or not the court is permanent. Permanent meaning that it is operating on an ongoing basis for multiple cases, contrary to non-permanent courts, which are only for a specific case. And another is that whether or not a case in that court is compulsory, meaning an applicant state has the right to begin proceedings and the respondent state has the obligation to participate in the case, provided that the court has jurisdiction and the application of the case is admissible. To know the nature and operation of the court or tribunal, we turn to the treaty that established it, usually termed as a statute, and sometimes its document on the rules of the court. The principal international court is the International Court of Justice, or the ICJ, which is one of the principal organs of the principal organization, the United Nations. It is the successor to the Permanent Court of International Justice established by the League of Nations. Fundamentally, the ICJ settles disputes between states, and since international law revolves around sovereignty, consent is required from all sides of the case, meaning the ICJ only has jurisdiction over a case if the state parties to the case consented to the ICJ's jurisdiction. Also, the judgment of the ICJ only binds the state parties of the dispute and in respect of that particular case. This is quite different from the setup of domestic law, as the domestic courts can proceed in cases concerning certain entities absent the express consent of those certain entities. Again, this requirement of consent is because of sovereignty, the supreme power in the land, which is only given to states and no other entity in the scheme of politics and governance. Prior to the proceedings or merits of a case in the ICJ in which the dispute is addressed, state parties to a case may raise preliminary objections to the admissibility of the case, whether the case has grounds to be admitted and heard in the court, and to the jurisdiction of the court, whether the court has authority to hear the case filed. This is seen as a necessary safeguard, which is under a time limit to assure due process in the international court. However, it can also be used as a delaying tactic if a state party to the dispute does not want the issue to be heard in the court. In terms of jurisdiction, the ICJ cannot decide on cases and disputes of states which are not members of the United Nations, or those states which have not signed the UN Charter, which contains the statute of the ICJ. For the ICJ to decide on a case, all state parties of the case must be parties to the statute of the ICJ, and all have consented to the jurisdiction of the ICJ. There are four methods a state party to the statute of the ICJ may indicate its consent: through number 1, special agreement, number 2, forum prorogatum, number 3, compromissory clause, or number 4, the optional clause. A special agreement or compromise is when states in a dispute may agree to take the dispute to the ICJ. This is done so through a treaty containing the wording of the dispute as it is to be presented to the court for its decision. This method of consent is only limited to the particular and immediate dispute, with both states explicitly consenting to the court for a peaceful resolution. The title of the case would be indicated with a slash. An example would be the asylum case, Colombia/Peru, which we discussed before. However, a state may also file a case in the court unilaterally, meaning by itself, though that state must demonstrate to the court that the other party has consented to the jurisdiction of the court, and this can be done through the remaining three methods a state may indicate its consent to the court. One is forum prorogatum, or in simpler words, belated or to follow consent. The respondent state, or states meaning the one responding to the application of the applicant state, may give its consent after the submission of a case to the court. This may even be done implicitly by just going through or participating in the process of the dispute, such as making a submission or counter memorial to the court. Absent this consent, the case will not be filed in the court. Another method is the compromissory clause. Hundreds of treaties contain a compromissory clause wherein an event of a dispute in relation to the particular treaty, the parties of the dispute in relation to the treaty will take the matter to the court. However, reservations may be made by states concerning the compromissory clause in a treaty it is bound to, meaning it consents with the treaty except for that particular clause, so long as the other parties of the treaty agree. Treaties like the Convention relating to the status of refugees, the Genocide Convention, the Convention on the Elimination of All Forms of Racial Discrimination, and the UNFCCC, or the United Nations Framework Convention on Climate Change, all include compromissory clauses. Finally, the last method of consenting to the jurisdiction of the ICJ is the optional clause, which is located in Article 36(2) of the Statute of the ICJ. This is simply a form of advanced consent, the opposite of forum prorogatum. State parties may recognize the jurisdiction of the ICJ as compulsory and without special agreement. Hence, it is automatic through a declaration, as long as the other state party or parties to the dispute also accept or reciprocate the same obligation, meaning the other state party or parties have also declared their consent to the optional clause. However, reservations may be also made in relation to the optional clause declaration of states. These reservations may be temporal in nature, covering only a certain time frame or meeting a deadline, or according to a subject matter, like excluding matters of territorial issues under the ICJ's compulsory jurisdiction, or through a multilateral treaty reservation, or what is called the Vandenberg Reservation, whereby disputes relating to a multilateral treaty are not under the ICJ's compulsory jurisdiction, or according to particular states, like the UK's declaration, where it excludes members of the Commonwealth from its optional clause declaration as they have other means of resolving disputes. More reservations include the Domestic Jurisdiction Reservation and the Self-Judging or Connolly Reservation, whereby matters falling to the domestic jurisdiction of the state are excluded from the optional clause declaration. These are seen as redundant reservations, however, as international courts generally have no jurisdiction over domestic issues. Beyond cases, the ICJ is also authorized to answer legal questions asked by the UNSC and the UNGA. The specialized agencies, when authorized by the UNGA, may also ask legal questions within the scope of their activities. And answers to these legal questions are called advisory opinions, a non-binding and sometimes authoritative take on the ICJ on a particular matter. Other international courts and tribunals, all with their own means of assuring admissibility, consent, and jurisdiction, include the International Tribunal for the Law of the Sea, as established by the UN's Law of the Sea Convention, the International Center for the Settlement of Investment Disputes, or ICSID, which deliberates cases between host states and foreign investors, the appellate body of the World Trade Organization, which settles trade disputes of WTO member states, the International Criminal Court, or the ICC, which is the first permanent international criminal court and mainly handles cases against individuals concerning genocide, war crimes, crimes against humanity, and aggression. Other international criminal courts and tribunals include the ICTY, or the International Criminal Tribunal of the former Yugoslavia, and the ICTR, or the International Criminal Tribunal for Rwanda, which were both created by the UNSC through separate resolutions in order to give justice to the victims of the atrocities and international crimes committed by individuals in the respective states. As we've seen, international courts and tribunals are usually attached or associated to international organizations, with the ICJ statute as an annex to the UN Charter, the ICTY and ICTR created through UNSC resolutions, the ITLOS as one of the courts of the LOSC, and the appellate body of the World Trade Organization. As we can see, there are a plethora of international courts and tribunals, all talking about different subject matters, all applying the concepts of jurisdiction, immunity, consent, and admissibility, in respect to the sovereignty of states.